Hey everyone, Rob Ryder. It's Tuesday, February 26th, 2013. I believe it to be the 26th. We're talking about the difference between abstract and torrens land. And this little blurb is out of the state of Minnesota that went to the torrens system. But it says abstract land refers to parcels of land that have not been registered, or more commonly, land that is not torrens. Prior to the enactment of the Torrens Act, all land was abstract land. The Office of the County Recorder accepts all instruments for recording which affect non-torrens land, in other words, abstract land. Again, this is for Minnesota. In order to determine the status of the title of an abstract land in Ramsey County, private abstract companies prepare new or continue already existing abstracts of title. An abstract of title is a compilation of all the instruments, beginning from the original grant or land patent from the U.S. government affecting the particular parcel of land under examination. Said all instruments, liens, encumbrances, whatever it is, will be on the abstract of title. And they have private abstract companies apparently doing it. And that may not be so strange, as we'll see. The abstractor makes entries in numerical order of only the essential parts of each instrument shown, although sometimes the abstractor will photocopy the instrument, show it as an exhibit to the entry. Okay, so that's the idea of the abstract. It just has little parts on it. Basically, going to tell you where the file is that has the instrument in that it's talking about, that it's affecting the title to that particular land. In general, attorneys examine the abstract and from such an exam issue a title opinion. Each time the title is transferred, the abstract must be continued to date and re-examined, again from the original grant or patent to the present date. Over time, the abstract becomes longer, bulky, and more difficult to examine. So it says, in general, attorneys examine the abstract. Well, why can't specifically you examine your abstract? You ought to be able to. It's going to list all the liens and encumbrances on your property. Now, by contrast, land which has been registered or torrens is governed by a specific statute. One of the hallmarks of the registration proceeding is the issuance of a certificate of title. So again, registered land has certificate of titles, and deeded land has abstracts of title. In registered land under the torrens system, the deed does not convey the title. It gives the authorization to have the owner's certificate of title updated to show that you're the owner. In abstract land, the deed does convey the title. However, it has to be properly recorded. And we're going to see some of the tricks they're using that, maybe we're not really recording it the way we think we are, and that Register of Deeds office where it sits now isn't the right place. Okay, but effectively this replaced the old abstract of title. In general, only those matters appearing on the certificate of title need to be examined immediately following the judicial hearing and signing of the decree of registration. So anything in the torrens system, because it has a decree of registration, a decree comes from a court of chancery. There was a judicial hearing first for the initial registration, and that's why the torrens system is under the court of chancery, because they're the ones who allowed the first registration. The decree is filed with the registrar, who then issues a certificate of title in the name of the owner. Already did 2 videos on that stuff, so we're trying to figure out what the difference is. So this is for Michigan, because we have abstract, system of abstracts of title, land in county. In the several counties, the state of Michigan are authorized and empowered to purchase or make, establish, maintain a system of abstracts of title to all lands in said county, to make and sell abstracts of title, yada yada yada. The action of any county in this state heretofore taken or had in compliance with the provision of this act is declared to be regular and legal. Okay, so the Board of Supervisors of any county shall hereafter desire to act under or by virtue of authority foresaid, the Board of Supervisors of such county shall, by ordinance or resolution duly adopted, make provisions for buying, making, establishing, maintaining such system of titles, so forth and so on. The ordinance or resolution may provide for track index, card index, cross-reference index, or any other index or reference system or systems as shall, in the judgment of the said Board of Supervisors, notice it said judgment, they're a court, best meet the needs of the county or community to be served. The Board of Supervisors is a court. Sometimes it's called the county commissioners. I think that's what they called it in Illinois. And it said the county clerk, since 1818, has been the clerk of the court of the county board of supervisors or county commissioners. They are a court. And they're the ones who are going to set this up. And so they're going to have a ordinance or a resolution that sets up the abstracting system that explains everything about it. And so you would go to their clerk, who is in Michigan, the county clerk, and ask to see the ordinance or the resolution that allowed the abstract system to be set up for the county. And it'll tell you if it's by track index, card index, cross reference, So that's one way to find out what there is. What is a track index? Is a document which summarizes real property transactions and certain yada yada yada, register of deeds. The information is organized by section, with a section relating to 1 square mile. Each section is presented in a 2-page representation, usually by representing the northwest quarter and the upper left-hand, top left of the page. In other words, big book, 2 pages, makes 1 mile, 4 quarter-mile sections. But the section is a 1-mile section, so that's how it starts out in a track book. The other quarter sections are placed in a map relationship to the northwest in each quarter section area. All transfers are listed in a chronological order, often regardless of any subdivision or quarter section. Each entry includes several cross-reference details such as the names of the grantor, the grantee, the volume and page of the deed books, of the date, and other identifying characteristics of the transfer, for example, the type of deed. Typically, when 1 quarter section fills with its listings or transactions, a new volume is begun, so that all transactions in a period are found in the same volume. Also, the number of sections within a jurisdiction dictates how many volumes are needed for a single period. So the number of sections, right? How many sections are there in the county? Because a section is a square mile. That's how many tract books there would be. And so you're in a particular tract, based on what the information is on your warranty deed, you could say, I want to see the tract book that has the tract information for the property listed on my warranty deed. Now, this is in Michigan. Before we go here, you're going to have to forgive me for just 1 second. Okay, we're back. Where was I? Right here. Okay, so any board of supervisors so acting may appropriate money within the limits allowed by law and entered into authorized contracts, appoint and employ, or authorize the appointment or employment of agents and servants to have charge of, perform labor on, and have care and custody of the books, record systems, and other property in the county, and do all things necessary to carry out the provisions of this act. In Michigan, we have lots of abstract companies, and I think the Board of Supervisors are running those companies, as we'll see. But again, this would all be in the act or the resolution or the ordinance that set this up. The ordinance or resolution may provide that the Register of Deeds shall be the abstractor, right? How you got to know who it is? Look at the ordinance or resolution that created the system. Or may provide for the appointment or employment of a superintendent or abstractor who shall perform his duties under the supervision of such officer or officers of the county as shall be designated in such ordinance or resolution. And the county clerk will have the ordinances and resolutions for the Board of Supervisors because she's the clerk of their court. Abstractor powers and duties: to keep and maintain said system of indexes and abstracts up to date at all times in every particular, promptly entering upon the records of said system of every deed, mortgage, release, discharge, attachment, lien, sale, lis pendens, agreement, or other transaction appearing on the records of the said county in any manner affecting the title to any of the lands in said county. And there's where the lis pendens is. It's not the notice of lis pendens, it is the lis pendens. And it's in the abstractor's office, and it's on the abstract title to your property. Collect all fees to promptly furnish information concerning the condition of title to any such lands to any person inquiring therefor. So, there you go. They're required by law to furnish you the information. Has the full faith and credit of the county. Each abstract shall have attached a certificate that all conveyances and other matters of record in the public offices of the county affecting the title to the property covered by the abstract are correctly set forth in the abstract. That will be certified. And it will say something county, abstractor of some county, name of abstractor, name of county. System of abstracts of title, public inspection. All books, records, indexes, and memoranda of the systems hereby authorized shall at all reasonable hours be open for inspection by any person lawfully entitled and have access thereto. Don't have to ask them to bring it to you. You can say, I want to go inspect them. I'll let you know what I want after I go and look around and see what you have. Treat it like a library. This act is intended to be declaratory and existing rights and powers of counties acting by and through their boards of supervisors to provide a definite uniform method to exercise thereof, but if necessary to its validity or operative effect, this act shall be deemed to be a grant of rights and powers. Okay, somebody granted them rights and powers. The provision of this act shall apply only to counties having a population of 900,000 and upwards, and those counties that now have county abstract books and are operating abstract offices. It shall be the duty of said board to submit to the electors of said county the proposal for the said county to own and operate an abstract office, and the books, indexes, etc. necessary to be conducting of such abstract office. So again, these abstract offices I'm talking about, they're not in the county building, but it seems like there's one per county or there's one for a couple counties, and they call them abstract offices. And I just think that they've been done by this resolution or ordinance, set up as separate businesses, but that's where the abstracts are. But it's done for the county, so therefore it's public record. Let's see. Fees, register deeds, apposition of fee for Charter County, page defined. For entering and record a deed, mortgage certified, okay, $8 a page. I don't know what I was doing that for. Except for the fee for tax index searches that shall be based on cost established and maintaining a tract index. So it could be that it's the register of deeds. It could also be that it's these companies. The way you find out is by the ordinance that's been recorded in the county record, kept by the county clerk. Fee of $2 for entering and recording a deed, mortgage certified copy attachment, notice of pendency. Okay, notice of pendency. Now that notice isn't that's normally a notice of lis pendens. I think that's what I mean here, the notice of lis pendens. Not the certificate of the pendency or the suit of the pendency, but just the notice of lis pendens, not the lis pendens. Alright, so that's about the abstract. Now here's what they did in Michigan, because the deed should convey the title. And once you record it, it should be done. But it says, and this is in the MCL 211.135, which is in the general taxing statutes, not in the recording statutes, you find this section that says recording of conveyances, tax certificate, accepted conveyances, register of deeds, violation penalty. If any deed or land contract, plat of any township, village, addition to any town site, village, or city plat, or any other instrument for the conveyance of title to any property is presented to the Register of Deeds of the county in this state for recording or filing, the Register of Deeds shall require all the following from the person presenting the instrument for filing. You need to have a certificate from the state treasurer or the county treasurer of the county stating whether there are any tax liens or titles held by this state or by any individual. A certificate that all taxes due on the property have been paid for the 5 years preceding the date of the instrument. So preceding the date of your warranty deed. Not today, right? What day was the warranty deed done? Boom. 5 years prior? Boom. Need a certificate. And if there's any on there right now. And then a certificate from the city, village, township treasurer in which the property is located, whether there are any tax titles or certificates of sale held by the city, village, township, or any individual against the property to be conveyed. In other words, is there maybe a lis pendens put in there by an individual? A certificate that all tax titles, tax certificates, or special assessments sold on that property to the city, village, township have been redeemed for 5 years preceding the date of the instrument. Again, 5 years before the instrument. If the certificate or certificates required under Section 1 are not provided, the person presenting the instrument for recording shall not record the instrument until the necessary certificate is presented. The Register of Deeds shall note the fact on the deed that the required certificate or certificates have or have not been presented to him or her when the instrument is presented for recording. Well, I don't think anybody in Michigan has a warranty deed is going to find on there anything from the Register of Deeds saying that there's been certificates or not been certificates presented. Yet you have to have these certificates to record it. If the person presenting the instrument refuses to procure the certificate or certificates, the Register of Deeds shall endorse the fact upon the instrument over his or her official signature and shall refuse to receive and record the instrument. You can't record it without the certificates. It's not been recorded. You need to go to these taxing offices and get the certificates. So in Michigan, you need to look at 211.135 and just do what it says. Go to the state treasurer or from the county treasurer and get his certificate about the tax liens and that they've already been paid, and then go to the city, village, or township and do the same thing with the treasurer there. Otherwise, you can't record it. Okay. And then these are the ones that don't need to have it. But so that's how I did in Michigan. Now I'll do a quick segue here. This is how they did it in New Hampshire. Another abstract state. It says Section 78B1. A tax is imposed upon the sale, granting, and transfer of real estate and any interest therein, including transfers by operation of law. Each sale, grant, and transfer of real estate, and each sale, grant, and transfer of the interest in real estate shall be presumed taxable unless it is specifically exempt from taxation under some other section. The grant of the tax is 75 cents per $100 or fractional part thereof of the price or consideration for such sale, grant, or transfer. So obviously a sale and a grant are different because they're listed different, and really a grant is a gift. Sale is when you buy something, a grant is a gift. Okay, except where the price of consideration is $4,000 or less, there should be a minimum tax of $20. So here's one for New Hampshire, and it says for consideration paid, grant to Randy and Elaine, okay, the property, right? For consideration paid, there's no amount on there. It must be less than $4,000. Therefore, your tax is going to be $20. right? For the price or consideration for such sale, grant, or transfer. For consideration paid, grant to. There's no amount. It's less than $4,000. Minimum tax, $20. However, there are non-contractual transfers, means a transfer which satisfies three elements of a gift transfer. A donative intent, I grant it to you. Actual delivery, I give you the deed. Immediate relinquish of control, the deed transferred, conveyed the title to the land. It is a non-contractual transfer. In the Torrens system, the warranty deed or the deed between the party, the grantors and grantees, is really just a contract between the parties. It's a purchase agreement, and it's the authorization for the registrar to make you the new owner on the certificates of title. But this is the abstract system. Price or consideration means the amount of money or other property services value to money which are given in exchange for real estate. And again, right? I don't see no amount of money written on here. I just see that it was granted. Cool. But let's go on. Okay. Evidence of payment. The payment of the tax imposed by this chapter shall be evidenced by stamps. By stamps or other indica, as approved by the Commissioner of Revenue Administration, attached to the instrument in writing by which any real estate or interest in real estate is sold, granted, assigned, transferred, or otherwise conveyed to or vested in a purchaser or grantee or in another person as purchaser or grantee's at the purchaser's or grantee's direction. Okay, what's the evidence of payment? A frickin' stamp. The excise stamp from the Commissioner of Revenue Administration. Well, who's got to pay it? Well, it says the purchaser. Grantee, assignee, or transferee of any real estate or any interest in real estate shall buy and attach stamps. The grantee needs to do it. But wait, the seller, grantor, assigner, or transfer of any real estate or any interest shall buy and attach stamps. Well, the grantee and the grantor both need to buy stamps. So there better be two stamps on there, right? Or the seller's, the grantor stamps and the grantee stamps. Well, when we look at this one here, there is one stamp. Right, now this is for $22.94. Forgetting the amount, where's the other stamp? There's room for one. It's not on there yet. Department of Revenue Administration, real estate transfer tax. Right? Pretty clear. Well, Elaine says she didn't do it, so the grantor must have. But what's Elaine going to pay? Is she going to pay $2,294? No, she's going to pay $20 because there is no amount of money listed on the warranty deed. Therefore, the consideration was less than $4,000. Therefore, the tax is $20. But until you do that, you can't record it. Stamps and indica. The Commissioner of Revenue Administration shall determine and prescribe the size, shape, design, stamps, and their denominations, and shall approve the use of any machine or mechanical device used to produce of payment and tax imposed by this. The stamp shall be for sale at the Registry of Deeds in each county and at such other places as the Commissioner shall determine. So if you want to know who the lowercase Register of Deeds is, you would call this Commissioner's office and say, hey, who's the Register of Deeds in my county that I can get my revenue stamps from per Law 78B5? And see what they say. Recording the stamps or other indica of payments of the tax imposed by this chapter shall be attached to the deed assignment, or other instrument in writing before recording the same, unless the instrument bears a statement that the transaction is not subject to the tax imposed by this chapter. Until they're on there, it can't be recorded. And where do you want to record it? You want to record it in the Register of Deeds office. But what Register of Deeds? Well, the one that can give you the frickin' stamp. When you find the Register of Deed that has the stamp. So my point is, if you go to where this is now in the Register of Deeds office, right? I don't believe that they put this stamp on. This is coming through revenue, right? This is the county auditor. This is, the assessor. This is a different office. That's actually the office we want to record these things. So you want to get the stamp put on there and hand it to them, say, there, now record it. And now they're going to record it to show that you're the owner. Or so it appears. And John and Elaine are going to find out. They got a court case on Thursday again. It's their turn up at bat, right? And we're going to go see if we can get this thing handled beforehand. Again, there's the one where the bank didn't answer their complaint. That basically the bank didn't put in a complaint, and they didn't. The bank didn't show up in court. Neither did the attorney. The judge did a continuation or reconsideration, I think it was, for 10 days, and then eventually the attorney of record put in a special appearance. It really hasn't gone anywhere since then, and they're supposed to have another hearing on Thursday. And so, now we have some things to tell the judge. Look, Judge, I need to get a revenue stamp and have it recorded in the Registry of Deeds, but no one will tell me where the Registry of Deeds is. It isn't the one I got it from because, they can't give me a revenue stamp. And according to the law, 78B5, they like their laws. Well, let's give them one, right? Stamp shall be for sale at the Registry of Deeds in each county. Right, so I want to know the Registry of Deeds. Basically, tell me everybody in the county who can sell these frickin' stamps, and I'll go to each one until I find the Register of Deeds. But they can't give me a revenue stamp. It ain't the right place. Okay, what else we got? Okay, warranty deeds. For conveyance of lands, this is again in Michigan. Worded in substance of file A, B conveys warrants to C, D. Here describe the premise for the sum. Here insert the consideration. And the said conveyance being dated and duly signed, sealed, and acknowledged by the grantor, right? And guarantees quiet possession thereof, right? So this conveys the title. However, it has not been recorded. And in Michigan, it's not been recorded because you didn't go to get the certificates from the taxing or from the treasurers of the county and the municipality to say that all the taxes are paid. You need a certificate in Michigan. You need a revenue stamp in New Hampshire. You need in where was this? Oh, here we go. If you're in a home, this is in Illinois now. If you're in a home rule municipality, you have to have a revenue stamp. Real Estate Transfer Tax Act. Right? So even there, because not every place in Illinois necessarily use the Torrens system. But this says recording or registering instruments. Either one, anything that transfers the title of real estate or beneficial interest in real estate subject to a land trust. If it's a home rule municipality, has level of real estate transfer tax. Boom, you got to pay it. I think it's $10. I think it said it someplace that was $10, but anyways, you want to know? Read the Real Estate Transfer Tax Act, approved July 17, 1967 in Illinois. Can't have it recorded unless you have the proof of payment of municipal real estate transfer tax. That's all they're doing. They're keeping us one step away from what we need to have. The use of words warranty deed or similar. Any person who shall print, sell, or keep for sale any blank forms of deeds containing the words warranty deed or some other stuff, or any similar words printed or written thereon, unless the deed is in fact an absolute warranty deed, and any person who shall knowingly use such deed for the purpose of conveying title, unless the same is an absolute warranty deed, shall be guilty of a misdemeanor. Absolute warranty. Guaranteeing possession, quiet title. Requirements for recording with the Register of Deeds. Again, lowercase Register of Deeds. Who is this masked man? Who is it? So we need to find out who it is in Michigan. But it says in Michigan that, the resolution may say that the abstractor is the Register of Deeds. So if you go and look again at the records to find out if by resolution or ordinance what set up the abstract system, it's going to tell you who the abstractor is. And it shall be the Register of Deeds unless they appoint somebody else. The address of each grantee, the address of each of the grantees in each deed of conveyance or assignment of real estate, including the street number, address if located within a territory where street number addresses are in common use, or if not, the post office address. There is that post office address again. The address of the post office. So the problem is, since ours hasn't been properly recorded, right? We're not seen as the owner on the paperwork. Whoever the last guy was is probably seen as the owner on the paperwork, and they're sending it to him on some to some address that doesn't really exist as far as we're concerned, right? If we put the grantee one in and have it recorded and it has our address on it, well, from then on, that's the address they're going to use to send you the mail. Right now, they're using some freaking post office address, and it's not coming to you. It's going to the post office. Nobody picks it up. 30 days later, it goes down to Atlanta, down to the lost letter file, and they get over 90 million pieces of lost mail every year. I wonder if some of it's this paperwork. Oh, what else we got? And that was really nothing there. To record. Sometimes questions arise. This is Bouvier's to record. The act of making a record. Sometimes questions arise to when the act of recording, the act of making a record, is complete. As in the following case, a deed of real estate was acknowledged before the Register of Deeds and handed to him to be recorded. And at the same instant, a creditor or the grantor attached to the real estate. In this case, it is held that the act of recording was incomplete without a certificate of the acknowledgement, and wanting that attaching creditor had the preference. So in this particular method, you would have to get a certificate of the acknowledgement, even though it said a deed of real estate was acknowledged before the Register of Deeds and handed to him to be recorded. Well, that isn't good enough. You also have to have a certificate of the acknowledgement, right? It took two things to do it. And that's all this is really showing. It takes two things to happen. But in all conveyances deeds which may be de facto recorded and not be considered as giving notice, in order to have this effect, the instruments must be such as authorized to be recorded, and the registry must have been made in compliance with the law. Otherwise, the registry is to be treated as a mere nullity and will not affect the subsequent purchaser or encumbrances unless he has such actual notice as would amount to a fraud. Basically, if it isn't done by the way they say to do it, whatever you've done is just a nullity. Recorder, a judicial officer of some cities possessing generally the powers and authority of a judge, the office of recorder. Anciently, a recorder signified to recite or testify on recollection as occasion might require and had previously passed in court, and this was the duty of the judges. Anciently, recorders signified to recite or testify on recollection as occasion might require what had previously passed in court, and this was the duty of the judges, thence called recorders. Now, we have this thing called the certificate of live birth. Testify on recollection as occasion might require. Still figuring out what to do with that certificate of live birth, but it's going to be in these same offices. An officer appointed to make record on enrollment of deeds and other legal instruments authorized by law to be recorded. Okay. When a civil action affecting title to or possession of real or tangible personal property has been tried in the county other than the county in which the real or tangible personal property is situated, the clerk at final judgment therein must certify under a seal of office, transmit a copy of the judgment to corresponding court at any county in which the real or tangible property affected by the action is situated. So, got two different jurisdictions. You have a court called the Commissioner's Court, and then you have a court called the 16th Judicial Court or 8th Circuit Court or whatever it is. Two different jurisdictions. They're taking these actions to the Commissioner's Court, filing a petition, whatever they're doing to start a case, because all the lis pendences and everything they're all listed in the county recorder's office, and she's the clerk of the Commissioner's Court. So it went to the Commissioner's Court, and all the judgments are supposed to be listed there. Anything to do with property, real or tangible personal property, such as a negotiable instrument. And everything in the registry is considered personal property in the Torrens system. Right? Because when you look at the tax sale, it doesn't show any land was sold. Tax sale, acreage, 0.00. They're selling the negotiable instrument that's under your landed estate, your all capital letter name. That's what they attached. And we're just looking in the wrong office. To render the filing of a complaint constructive notice to purchaser to render the filing of a complaint constructive notice to the purchaser of any real estate, the plaintiff shall file for record with the Register of Deeds of the county in which lands to be affected by such constructive notice are situated a notice of the pendency of such action, setting forth the title to the cause and the general object thereof, together with a description of the lands to be affected thereby. But they had to file a complaint first before they could do the notice. Right? So where's the complaint of constructive notice? Not the notice of the pendency. Where's the frickin' complaint? It's in the county clerk's office, went to the Baron's Court, called the Commissioner's Court. Such a notice may be filed with the complaint before the service of the summons, but in that case, personal or substitute service of the summons must be made upon the defendant. Or they can put it into the Register of Deeds office as a notice. When a defendant sets up his answer or counterclaim upon which he demands an affirmative judgment affecting the title to or possession of, use and enjoyment of real property, he may file for record a like notice at the time of filing his answer or at the time afterwards before final judgment. For these purposes, the defendant filing such notice is regarded as the plaintiff, and the plaintiff is regarded as a defendant. But this would be with the county clerk, wouldn't be with the circuit court clerk, in my opinion. It's not in those court buildings, it's wherever the commissioners are. And when Roe went to look at the commissioners where they meet, it looks like a really, really nice courtroom. So, Anywho, just some more stuff on Liz pendances. I'm still looking at it, but I wanted to do this part today on on abstracts. And so in New Hampshire, what John needs to go do is get himself a stamp right here. Put it right here in this big spot for the grantee, so that we can say that the grantee has paid their taxes. Why does he need to do that? Well, because Section 78B4 says the purchaser, grantee, assignee, or transferee of any real estate or any interest in real estate shall buy and attach a stamp. And by God, so will the seller. And there's only one on here, and Elaine didn't buy a stamp. But yet there's room to put a stamp on the paper right there. And then it can be recorded, and she'll be seen as the owner. Okay, that's it for now. You all have a great night. See ya.